Let me tell you why you're here. You're here because you know something. What you know you can't explain, but you feel it. You felt it your entire life, that there's something wrong with the world. You don't know what it is, but it's there, like a splinter in your mind, driving you mad. It is this feeling that has brought you to me.
All right, let's do a test here. Can everybody hear me okay? Hello, hello, hello. Hello, hello. Yay! In the mud. You're already mad. Hey, Silver, how's it going? Hey, sorry, I've been away and I haven't really been posting too much. I've been neck deep in this whole AMC thing. I hit the ejection button uh, and I got out of it though. I got out of it when it hit. I bailed. I'm sorry, but I bailed when it hit around 12. That was my ejection seat. I did buy back into it today at like not that much. I was overextended on that whole AMC thing, the stock thing. I had got way too into it. So I desperately had to hit that ejection button. But the good news is I'm back in it to a lesser extent. But I bought back into AMC for anybody that's interested this morning at around, I think it was like right around $7.50 or whatever like that. So my risk isn't as much. And I'm going to just let it go. We'll see what happens. I'm going to ignore it. Pretend like just pretend like I didn't even do it. If it crashes, it crashes. Oh well. And if the squeeze happens and it goes up, well, that more power to the people. But there, the full transparency. I know some people had seen my community posts on my page that I was like 3K deep in AMC. Well, I had gotten up to about 5,000 deep in AMC, and last night, when the hedge funds manipulated the stock price by putting in thousands of small orders with each other to ladder down the price of the stock. Total market manipulation. I mean, totally illegal. But what are you going to do? You know, is the SEC going to do anything about it? I doubt it. So I had to hit the ejection button. But I bought back in today. So we're still in it. But I ended up saving a crap load of money by doing it that way, just ejecting yesterday and re-implementing today at the 750 price range. So we'll see what happens. All right, that's to anybody out there that was curious about that. But the main topic of this live stream: could this possibly be the end of qualified immunity for cops and public officials? And there's a video an attorney put out a video today that was emailed to me by one of my subs. And I watched the video and I looked into it and I went, holy crap. Holy crap. About 40 years ago, a lot of you know, about 40 years ago, or give or take, the Supreme Court implemented qualified immunity, created it out of nowhere. All right. No legal backing to it or whatsoever, just out of thin air, pulled it out of their backside that said, you know what? If a cop does something and violates your rights, but under the similar circumstances, if no other cop has done it in the past and no court has ruled that the officer should have known because of case law that he couldn't do that, well, we're going to go ahead and throw out your lawsuit. So, and that right there, it created like a vortex, you know, like the Twilight Zone, because if a case comes up and gets rejected for qualified immunity, how is there ever going to be precedent? How is there ever going to be a case that says, no, 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 cops, you shouldn't have done that? It creates a wall where you can never breach and get above that. So cops will know, hey, that shouldn't have happened. So it created a very, very, very high standard for lawsuits against civil rights on public officials. And for like the past 40 years, we've seen that. An officer does something, take what was it, Colorado Springs, where that guy got tasered in the cojones. All right. Now, if he sues the police, and are they going to reject, the court's going to reject that lawsuit and say, there's never been a lawsuit that said cops can't taser you in the genitals for doing nothing, it's and squash that? That's the problem with qualified immunity. All right. Because these lower courts just keep dismissing case after case after case, and it gets up to the Court of Appeals, and the appeals court goes, yeah, the officers shouldn't have done it. Yeah, they did violate your civil rights, but you know what? There's never been a case like this where the cops should know better. So the Supreme Court just heard a case and put out a kind of a decision on it that pretty much just says now, hey, that's not what we meant. That is not what we meant when we created out of thin air. We farted, and out comes qualified immunity. It was never meant to be that high of a standard, because if you never have a case like that, how can there be a case like that? You see what I mean? It's just a loop. It's just a loop. How can you get past that bar? I'm rambling, like the guy that got tasered in the balls. I think it was Colorado Springs. If there's never been a case where an officer has tased some guy in the genitals, you're just going to throw out that lawsuit because the cop, I didn't know I couldn't do that. I didn't know that was cruel and unusual punishment. There's never been a case before. Okay, we're going to throw it out for qualified immunity. Cleo. Cat's going crazy. So there is a case. There's a law professor. Here, let's see if I can share a screen here. Share a screen. Chrome tab. Share. Bam. There we go. All right. I can't even pronounce his name. Chemerinsky. Erwin Chemerinsky. All right. SCOTUS hands down a rare civil rights victory on qualified immunity. Here, let's switch this out here. Bam. All right. Now let's go over this. All right. I'm just going to read it to you guys, and I'll end up posting the link somewhere. Decisions handed down without briefing, oral arguments. Okay. The U.S. Supreme Court's ruling about qualified immunity in Taylor versus Riojas might have been overlooked even by civil rights lawyers. But the case is significant because it is a rare instance in which the High Court rejected a claim of qualified immunity and made clear that no case on point is required in order to hold a government officer liable. You don't have to have an identical circumstance to breach qualified immunity in the lower courts, is pretty much what they're saying. But the case is significant because it is a rare instance in which, I already read that. Obviously, it's not possible to know whether it is an aberration because of extreme facts for what this guy had to go through, or if it's a new, more civil rights friendly approach by the Supreme Court. But a victory, by the Supreme Court in civil rights plaintiffs is qualified immunity cases notable and could matter in lower court litigations from here on out. Now, here's the facts, okay? Taylor v. Riojas, or whatever, however you pronounce it. Now, this is a shock, it's a shocking case to this, to hear what this guy had to go through. But when in the overall world of police conduct, like to me, it's not very shocking, and but although it is disturbing. Trent Taylor was a prisoner in Texas. He entered a psychiatric prison unit to receive mental health treatment following a suicide attempt. For a period of 6 days, he was confined. Whoa. In a pair of what the court rightly described as shockingly unsanitary cells. The court explained that the first cell was covered nearly floor to ceiling in massive amounts of feces all over the floor, the ceilings, the windows, the walls, and even packed inside the water faucet, making pretty much it impossible to get a drink of water. For 4 days, Taylor did not eat or drink for fear of contamination. Also note, when you're on suicide watch, they strip you down naked. So you're naked in this, he's naked in this cell that is completely, it's like a crap bomb exploded in there, pretty much. All right. Somebody made a freaking crap bomb and let it explode in there. And this is what this guy had to live in for a period of 6 days. Taylor was then moved, let's go down, to a very cold cell with only a clogged drain in the floor to dispose of bodily waste, the court said. Taylor held his bladder for over 24 hours, but he eventually and involuntarily had to, relieve himself, causing the drain to overflow and raw sewage to spill across the floor. And because the cell lacked a bunk and because Taylor was confined without clothing, he was left to sleep naked in raw sewage. Taylor sued the corrections officers, alleging that they violated the Eighth Amendment by inflicting cruel and unusual punishment during his incarceration. The district court ruled in favor of defendants based on qualified immunity, holding that they could not be held liable because they did not violate clearly established law that any and every reasonable officer should know. Excuse me. How could a reasonable officer not know that making somebody naked, live in a small cell with no bunk, covered in feces, doesn't violate his civil rights? You don't need a case to understand and know that, okay? They did it on purpose, okay? They didn't care about this guy. The United States Court of Appeals in the Fifth Circuit affirmed the dismissal of Taylor's case, though. The Court of Appeals ruled that Taylor's constitutional rights were, in fact, violated. Being placed in these cells was cruel and unusual punishment, but it also concluded that the officers were protected by qualified immunity. It said the officers could not be held liable because the law wasn't clearly established that prisoners couldn't be housed in cells teeming with human waste for only 6 days. Oh, jeez. Really? Like, oh boy, there hasn't been a case like this, so they get qualified immunity. That is not what the Supreme Court meant. That's not the bar they set up that you had to hurdle over in these cases. It was never meant to be that focused. And here's why it matters. Any government officer sued for money damages for allegedly violating the Constitution has an immunity defense. Some are protections by absolute immunity, like judges for their judicial acts, legislators for their legislative acts, prosecutors for their prosecutorial acts, law enforcement personnel for their testimony, and the president for acts taken in carrying out the duties of his office. All other government officers have qualified immunity, but they are immunity when they are sued for money damages. And over recent years, the Supreme Court has expanded the protections of officers under qualified immunity and repeatedly stressed the need for a plaintiff to show a case, any case on point, in order to establish liability. The court has said the plaintiffs can overcome qualified immunity only by proving that the defendant officer violated clearly established law or case law that every reasonable officer should know, and that is a right established beyond dispute. In one of the more recent formulations of qualified immunity, the court in District of Columbia versus Wesby was emphatic in how difficult it is for plaintiffs to succeed. The court stated, Existing law must have placed the constitutionality of the officer's conduct beyond debate. This demanding standard protects all but the plainly incompetent or those who knowingly violate the law. To be clearly established, the legal principle must have a sufficient clear foundation in that existing precedent. The rule must be settled law, which means it is dictated by controlled authority or a robust consensus of cases of pervasive authority. It is not enough that the rule is suggested by the existing precedent. The precedent must be clear enough that every reasonable official would interpret it to establish the particular rule the plaintiff seeks to apply. In case after case, the Supreme Court found officers were protected by qualified immunity under this standard. From 1982 to 2020, the court dealt with qualified immunity in 30 cases. The plaintiffs prevailed only in 2 of those cases. Hope v. Pelzer in 2002 and Grove v. Ramirez in 2004. Thus, the court rulings in this case, the Taylor v. Riojas, for the plaintiffs and denied qualified immunity was notable just on that merit. There was 30 cases, and only 2 of those cases did they were able the plaintiffs able to breach the qualified immunity standard. 2 out of 30. That tells you there's something wrong right there. All right, but that's why we're here to discuss Taylor v. Riojas, okay, and what the Supreme Court has finally decided to tell us about qualified immunity. But the court's reasoning also is potentially quite significant. The court, in its per curiam opinion, relies on 2 prior decisions, United States versus Lanier and Hope v. Pelzer. These are the rare cases where the court said that there does not have to be a prior decision on point to overcome qualified immunity. Right there. 2 cases says you don't have to have a case just like yours to succeed and squash qualified immunity defense. Okay. United States v. Lanier in 97 was not a civil suit under 1983, but was rather a criminal prosecution under 18 U.S.C. 242. Both 1983 and 242 were enacted as part of the Civil Rights Act of 1871. The former creates civil liability and the latter criminal liability for those acting under color of law, state law, who deprive the person of rights protected by the Constitution. And Lanier involved a state court judge who had sexually assaulted and harassed women in his chambers. Ooh, naughty boy. The U.S. Court of Appeals for the Sixth Circuit ruled in favor of Lanier, emphasizing the absence of prior decisions, specifically deeming such conduct to be a violation of constitutional rights. Okay. All right. He shouldn't have done that. The judge shouldn't have done that. He shouldn't have sexually harassed and assaulted women in his chambers. But since there hasn't been a case showing that a judge can't do that, we're going to give him qualified immunity. That's the ridiculously of qualified immunity standards these days. The Supreme Court reversed and stressed that a reasonable person surely would know that such behavior, i.e., sexually assaulting women in the judge's chamber, is a violation of a woman's constitutional rights, even though there's never been a case like it, right? In Hope v. Pelzer, a prisoner was tied to a hitching post and as punishment and left in the hot sun for many hours. The 11th Circuit found this to be cruel and unusual punishment, but said that the prison guards were protected by qualified immunity because there was not a prior decision that the use of a hitching post was unconstitutional. The Supreme Court did reverse and ruled that the defendants were not entitled to do the qualified immunity, even though there has been no case of jail workers torturing somebody to that extent. The court, in an opinion by Justice John Paul Stevens, held that the key inquiry is whether the officer had fair notice that the conduct was a violation of rights. Stevens explained that the central question in determining whether a prison official could be held liable to Hope was whether the state of the law in 95 gave them fair warning that their alleged treatment of Hope was unconstitutional. The court explained, although earlier cases involving fundamentally similar facts can provide especially strong support for a conclusion that the law is clearly established, they are not necessary to such findings. Rather, a plaintiff can overcome qualified immunity by showing that the reasonable officer under the circumstances should have known that the conduct was wrongful. The court then reviewed the law as it existed in 95 and said the officer had fair warning that their conduct was unconstitutional. In almost 2 decades since Hope and Pelzner, the court repeatedly backed away from this approach and continually stressed the absence of cases on point as a basis for dismissing case after case after case based on qualified immunity. And the court did not overrule or attempt to distinguish Hope v. Pelzer, as the court just ignored Hope v. Pelzer. Now, Taylor v. Riojas is especially important because it reaffirms Hope v. Pelzer, and that there does not need to be a case on point for a plaintiff to prevail and overcome the qualified immunity standard and bar. In conclusion, in recent years, the court's qualified immunity decisions have come under sharp criticism by both liberals and conservative judges and commentators. Proposals have been introduced in Congress to modify the law in this area. Perhaps Taylor v. Ross is a response to that criticism and will lead to a court that will be more willing to rule for plaintiffs when qualified immunity is the issue. Or maybe the case is just a reflection on truly horrific facts of this individual case and will be an outlier in the court's future decisions in this area. But no matter what, it is important. It is an important ruling that has potential to matter greatly in lower court litigations. In establishing that Hope v. Pelzer remains good law and there does not have to be prior precedent on point to overcome qualified immunity. If anybody, we have just pretty much read that and summarized that, but if anybody wants to have that link to what I just read, I will post it there in the live chat so you guys can grab that link and post it on social media or anywhere you decide that you want to post it to. So yeah, pretty much there you go. Remove that. We're just going to get rid of that. So there. I thought that was important. I don't know how many of you have seen that or heard that, but yeah. That's one reason why there's such a push against qualified immunity and the high bar it sets, is because if an officer or a public servant does something that no other officer has done, and there's no other case been brought before the courts, how is there ever going to be precedent on that? I mean, if an officer decides to, do something totally absurd to somebody, but it hasn't happened to anybody else before, it isn't automatic that officer gets qualified immunity for it, because there'll never be a case. If you keep squishing these cases, there will never be precedent on it. It's like, oh, something new, we can rule on. Oh, whoops, you hit the qualified immunity ceiling. Sorry, we got to dismiss it. So, I mean, it's an impossible task. It is important. But I just wanted to go live and get that out there. It's an important decision by the Supreme Court on qualified immunity. This could be the first block. Cleo, knock it off. This could be the first block that we have to, in a whole wall, building that we're going to build, smashing qualified immunity. You want to come up? You want to say hi to everybody? Come on. You want to come up? Hold on. Come on. Want a treat? Come on. Come on. Good girl. Good girl. Come here. Oh, I got you. You can't get away from Daddy. There we go. Say hi, Cleo. Hi, everybody. We're doing good. Look at me. I'm getting so big. The new cat. Getting so big. Hi, Otto. And she's so cute. We'll make you a star. Yes. Look at the belly. Look at the dots on that belly. Look at the dots. All right, you can go. What? Hey, get off the keyboard. Get off the keyboard. Thank you. Yeah, Cleo's doing good. Was it Tom Wood? He suggested Cleopatra because of her striping. She looks kind of like a savannah. And I talked to Nancy about it, and she liked Cleopatra, but it was kind of a long name, so we just shortened it to Cleo. So that's her name, Cleo the kitty. But when we have to take her for vets and checkups, she goes by Cleopatra. When she gets in trouble, or we call her, it's Cleo. What you doing? All right, we're gonna wrap this up. I gotta get ready for work soon. Let's see. Let's highlight. Also, when they change arrest to obstruction when pulling over filming, like Freeman getting beaten for filming but charged with disorderly. Yeah. All right. So, yeah, I posted the link to the article. Even though I read it, it's a good read. So, and so far, a lot of lawyers and a lot of, well, not just lawyers, just a lot of people are kind of not really talking about that decision. It's almost like they don't want people to know, and that's why it's important to get the word out there that the Supreme Court, knock it off. The Supreme Court is starting to chip away, I think, at qualified immunity. So that it's a good thing. It's a good thing. Hey, bud grower, how you doing? Take care. QLD, good to see you, man. Oh, we had a super chat. Lackluster. Hey, man, that's definitely appreciated. Not solicited, but definitely appreciated. Hey, that's another. What is it? That's another 2 or 3 shares of AMC I can buy now. Oh man, I tell you, rules for thee, but not for me. All right. The peasants, you peasants can't do it, but us hedge fund people and people, with all the money and the power, we can. It's funny. It's funny. Stock manipulation is against the law. Yet these hedge funds are allowed to do certain things like step down ladders and price adjustments to push a stock price down to crush it. All because they don't want to lose another $1 billion. It's ridiculous. A shame Canadian. Hey, how's it going? Yeah, thanks, man. Here, we'll highlight you. Definitely appreciate it. You chiming in. It's starting to get chipped away. It's starting to get chipped away. I don't know if when you jumped in, but I posted a link. Here it again. Read this. If you're just if you're just joining in, there's a link for you. I want you to read that. It's a case that the Supreme Court just ruled on and overruled the lower courts that gave cops qualified immunity for making a guy sleep naked in a small cell on the floor, covered in human waste. The cell was just covered in human waste. But there's never been a case like that. So lower courts gave him qualified immunity, and the Supreme Court said, no, that's not what we meant. That is definitely not what we meant 40 years ago. Yeah. Whatever. One of these days, I got to visit Canada. Maybe when and if AMC goes to the roof, goes to the moon, maybe we'll visit Canada. But yeah, I bought back in on AMC to a lesser extent today when it was like $7.50 or something like that. We'll see. I have a feeling those hedge funds are still going to manipulate the market, and they're going to cover their shorts by forcing the stock price to go down. They're gonna pull every illegal trick that they can. The SEC is not going to do nothing to them. I hope it does, but all right, everybody, we're gonna get off of here. We got to get ready for work. We got to be at work at 3:00. I got something to eat. But I came across, somebody had sent me the link and some info on this, and I wanted to make a video about it, so you guys can read the article. Thanks for everybody that stuck around while you listen to me butcher it a little bit and try to read it to you. Hi, Fresno. Good to see you, man. Hey, what's up, Tommy? Cleo says hi, Tom. Bye, Langley. Thanks for everybody for jumping in here. Sorry it's so short. Hey, I'm going to try to be making, now that this whole AMC, GameStop thing's pretty much, I don't want to say over with, but since I'm in it to a lesser extent, and I'm just going to like put it on the back burner, I'll get back to creating more content. I've been absent for a little while because I've been too focused on the stock market. It's been fun to watch, but yeah, crazy. But we're gonna get back to work on the YouTube, so we'll get some more videos up. All right, everybody. Thanks again. Peace.